Ma'am, I want to say I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only. I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt. Objection hearsay. Objection hearsay. I'm not a sovereign.
We've got a crazy one today. A man who was in court for speeding pulls out his sovereign citizen script as if it were his ticket to avoid going to jail. The funniest part? He insists he's not a sovereign citizen. But we all know the truth. What are your thoughts? Is he or isn't he? Drop your ideas in the comments, and subscribe if you love this content. Let's get started.
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
This is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime.
This guy actually thinks you need a victim in court to be charged. Seriously? Does he honestly believe this nonsense? Here's the thing. You don't need a victim for something like speeding because traffic laws exist to maintain public safety, not just address personal harm. The goal is to stop careless behavior before it causes harm. Sovereign citizens love to twist this, thinking laws only apply if someone's directly hurt, but that's just wrong. What do you guys think? Is he faking it, or does he buy his own nonsense? Let's dive back in.
Victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So, your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with two signatures of the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, is a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Clerk. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it. Yeah.
Was it true that the day before the hearing, this guy sent his discovery request? Man, hurry up. This isn't how it operates. To provide both parties time to examine the evidence, discovery requests should be sent well in advance. You can't just send it at the last minute and hope it works out. This isn't Amazon Prime. Clearly, he's either trying to postpone the case or dodge the ticket completely. Or perhaps he simply doesn't know. What are your thoughts? Let's get started. Again.
That I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant, that I'm giving the benefit of including what he offers as a motion for discovery, was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas. That to my knowledge doesn't exist. The Butler County Clerk in El Dorado and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable, and I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last-minute motion for discovery is denied, and we are prepared to go to trial. Now, I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no.
This man either truly believes he is the smartest person in the room, or he has an IQ of 4. In any case, he's going to get a hard reality check. Refusing to show his face and tossing out snarky comments like he's got all the answers. News. Flash, buddy. The court isn't here for your little games. Behaving in such a manner before a judge simply makes matters worse. He checks all the boxes, but he says he is not a sovereign citizen. I have no idea what his strategy is, so let's get down to business.
Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay, or
I'm not a sovereign citizen.
all right. He's not a sovereign citizen. Go ahead, Mr. Revere.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim, and then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the...
Unfortunately, none of his genius work in that 7-page manifesto was grounded in actual law. And now that the verdict is in, it's all gone. It's priceless to see his expression when the judge stops his crap. He really thought he wrote the ultimate legal argument, but it's pure fantasy. Honestly, I think he believes every word of it. Let's get started again.